Azwi. Now, judgment in the application brought by the Fair Trade Independent Tobacco Association, or FITA, against the Co-operative Governance Ministers' decision to ban the sale of tobacco products during the lockdown was reserved in the Pretoria High Court yesterday. FITA described the ban as irrational and unreasonable, and the state, however, argued that the Co-operative Governance Ministers' decision to ban the sale of tobacco products during lockdown was legal and rational. And joining us now to talk about the merits of the case is Bulelwa Mabasa, who is a director and constitutional lawyer at Werksmans Attorneys. Thanks so much for your time this morning and welcome to Morning Live.
Thank you, Sakina. It's a pleasure to join you.
Bulelwa, firstly, what was your impression on the application that was brought by FITA and how it was argued yesterday?
Look, it's a very interesting matter. I think the first thing to point out is that there was not a constitutional challenge on the legality of the imposition of the lockdown itself. Unlike, for example, the other judgment that was handed down by Judge Davis last week. So here we're not dealing with whether or not the lockdown is constitutional, but rather a very narrow point on whether or not the tobacco ban is rationally connected with the reasons that have been given by the government for the ban. In other words, that the argument that was made by FITA was that there's no evidence to link the ban to any medical or scientific data or evidence that points to the fact that banning tobacco sales will have any impact on flattening the curve, or that not banning the continued sale of tobacco will overburden the public health system.
Now, speaking to that rationality test, they, of course, refer to the fact that the World Health Organization, haven't conclusively made that link between worsening cases of COVID-19 and the sale or the consumption of tobacco products. How strong a case do you believe that is, Bulelwa?
Look, I think the FITA has mounted a very compelling challenge. It is startling to my mind that it is actually the minister that sought to rely on the WHO reports and some of the HSRC reports, which actually did not necessarily support the case that they were mounting. In other words, that the WHO itself had found, in fact, that there'd been no peer review literature that goes to show a link between tobacco smokers and eventual death, or a need to, be in ICU or overburdening the healthcare system. So I think the challenge that is brought on by FITA is a very compelling one, especially when you also look at the fact that the minister seems to have almost a moral issue with smoking, but that does not necessarily mean that you can trump individual choice or even agency of individuals. So I think it's important to note that what FITA said is that obviously smoking, the dangers of smoking are well documented and well known, but that does not mean that within a state of national disaster, especially when there's no parliamentary process to oversee the regulations, that you do not then make drastic bans or legislative interventions where you do not have conclusive evidence to do so.
And of course, it brings to question once again, Bulelwa, the whole issue of weighing up constitutional rights and, of course, the regulations that have been brought about for the greater good of society, as it were, as a result of dealing with this COVID-19 pandemic. But is the ban on the sale of tobacco products, Bulelwa, is that during lockdown infringing on consumers' rights?
Look, the FITA was very careful to ensure and to make a point that this was not a constitutional challenge on the state's ability to protect the public health. So in other words, this was not a challenge around whether or not, individuals have the constitutional right to, to choose whether or not to smoke, but rather the challenge is on the principle of legality. And the difference between a constitutional challenge and a principle of legality is that in a principle of legality, we say, even as the minister is empowered to protect the public and to implement the Disaster Management Act, she should do those decisions must be underlined by some type of rationality. So it's very important to actually state that this was not a constitutional challenge per se, but rather that it was based on the principle of legality and the rule of law, which says that any decisions that are made, whether they are made as administrative decisions or executive decisions, which the minister is empowered to make, must be underlined by that principle of rationality and the rationality test.
Bulelwa, FITA also argued to that point that the minister overstepped her authority in declaring this ban. What's your opinion regarding that? Did the minister overstep?
Look, I think that the Disaster Management Act allows her to make regulations for in order to curb the spread or to flatten the curve of COVID-19. She certainly has the powers to do so, but those powers do not extend to the minister making such a decision without the necessary scientific evidence-based approach. And in fact, some of what FITA had argued was that without usurping the powers of the sovereignty of South Africa, that it was startling that nowhere else in the world has a response to COVID-19 being around the banning of tobacco. I think it's only Botswana that has followed South Africa's route. So that was also something that was put to the table by FITA to say that the world over there hasn't been a trend of seeking to deal with COVID-19 by banning the sale of cigarettes. In fact, another big point that was made was that when you since the banning of tobacco, that has made the illicit industry thrive even more, where people have continued to smoke, and where people have, in fact, more than 90%, I think is the statistic that was mentioned by a UCT report that was relied upon by FITA, that more than 90% of people have continued to smoke, and that scientifically banning the sale of cigarettes scientifically does not necessarily lead to the quitting of people from smoking, that, addiction does not work that way. That where you ban it, it will, automatically lead to people deciding to quit smoking.
And another point that FITA were very strong on, and they wanted to highlight this issue very pertinently, was the fact that the president had made an announcement that the sale of tobacco products would be allowed under lockdown level 3. And they say that the president must have made that particular announcement based on advice that he would have received from experts. And they go on to say that the minister is not necessarily an expert in this field, and they want to know what led to that reversal, as it were, of the announcement that was made by the president. Now, when the judges are sitting and listening to this, how strong a point is that in the entire framework of the argument?
I personally don't think that that's their strongest point in the argument. And the reason I say that is because I am, the point that was made by the minister, which I think was a valid point, was that the whole issue around an opportunity to be heard or your considerations to be heard is an issue that really talks to when legislation is being made, not necessarily in an executive decision function. So when the minister was making the regulations, she was acting in an executive function. So it's not equivalent to, for example, when legislation gets passed through Parliament and all of that. And secondly, I think that the president, when he made that announcement, he made it clear that he would welcome submissions and representations on the decision of the allowance on the sale of tobacco, that was not a fait accompli. The president had opened the door that further considerations would be taken into account. And so the potentially where the minister is kind of weak in that was that FITA argued that the minister did not provide sufficient records in the papers to show how that consultation process actually was done. But so I do not think that the mainstay, or rather that this particular argument around the president's U-turn is necessarily the highest point of this case. But that the most compelling argument is around this issue where the state itself relied, or rather the minister relied on two studies, one which did not make sense, and when further information was required, the HSRC study, the state couldn't back up the study, and secondly, the WHO study, which actually found the opposite, that there was not enough peer-reviewed literature done on the issue. So the issue around the president's U-turn, to me, is not where I think the strong, it's not the high watermark of the case that was made by FITA.
So in terms of determining the rationality of this particular judgment that is sought, how do you think the judges are going to weigh this up in light of the science that would back up this particular regulation? Because as you pointed out, you have the state, for example, relying on the HRC study, then you have FITA relying on the UCT study. How important is science and the scientific backing of this decision going to be in the judge's determination?
Very interesting question. I think Advocate Subel was at pains to say that this is not a case about judges looking at which study to place more weight on or which study to rely more on, but rather that the studies themselves have supported the view that actually there is no link between this banning of cigarettes. No, actually, not even banning of cigarettes, but rather there's no link between smoking and an eventual need for a bed in an ICU hospital, or that it will, or in fact, that smoking itself is a comorbidity condition that poses even a higher risk, more than say cancer or diabetes. So basically, when the full bench of the Pretoria High Court looks at this, they would have to look at the content and the conclusions that are reached by the WHO, and they will also look at the weaknesses or the apparent weaknesses in the HRC study as well.
Well, we're going to have to leave it there. Thank you so much, Bulelwa Mabasa, Director and Constitutional Lawyer at Werksmans Attorneys, talking to us about the High Court application that was brought by FITA to lift the ban on the sale of tobacco products. Very interesting arguments been made in that court yesterday, and of course, judgment reserved at this stage. Let's take a break before we get to news at 7.